If you're a California lawyer who accepts flat fees, you may have heard that the new rules of professional conduct, which go into effect on November 1st, 2018, change how you need to handle those fees. That's true. So let's talk about what you need to do. Flat fees are addressed directly in the new rules. This is a change. The old rules didn't specifically address flat fees. They were, of course, permitted. There's nothing wrong with a flat fee, but the old rules did not talk about them specifically. The new rules do. In doing so, the rules say that by default, a flat fee must go into a trust account. Now, this is going to be a big practical change for a lot of lawyers. There are plenty of flat fee lawyers in the state who have never opened a trust account. You've never needed one. If you don't accept costs in advance from clients, it's quite possible that you've just never had occasion to have an IOLTA. But this is a change, and so you really should have one just in case. That doesn't mean that you're actually going to end up needing it. There are some ways, not around the rule, but so the rule provides some ways that a flat fee does not actually have to end up in your trust account. So let's make sure we look very closely at those. The rules provide that if you are charging a flat fee, your fee agreement needs to disclose to your client that they have a right to have that fee held in trust. But they can agree that it's all right for you not to put it in trust. If the fee exceeds $1,000, the acknowledgement from the client that it's okay to go into your operating account needs to be in writing. Now, I'm a big advocate that all fee agreements should be in writing anyway, but the Business and Professions Code does allow us to operate without a written fee agreement if the fee is under $1,000. And so the way that the rule on disclosures of flat fees is written, it tracks whether you actually need an agreement to be in writing in the first place. So if you don't need it to be in writing, the disclosure about where the fee goes can also be oral. Now, another disclosure that must be in your fee agreement, if you're accepting a flat fee, is that if you don't complete the work, the client might be entitled to a refund. What's new about this is that it needs to be in writing in a fee agreement. It's not actually new that the client might be entitled to a refund. A lot of flat fee lawyers have assumed that because the fee agreement says that they have earned the fee when the client pays it, that means that they never have to give a refund. That's actually not true. If you take a flat fee, even under the old rules, and you have in your fee agreement, I've earned this as soon as you've paid it, but then you never do the work, or you do half the work and then walk away from the client, you actually still have to return a portion of the fee. To not return it would be a violation of the rule against an unconscionable fee, and you would be required to return the portion that was not earned. So that part of the rule is widely talked about as a change, but in fact, in substance, it's really not. Your fee agreement should also include a provision that explains when the fee is earned. It really should not say, as many flat fee lawyers have been saying, that it's earned as soon as it's paid by the client, because it's just really not. I would not want to be trying to explain to the state bar or even a fee arbitrator that somehow by receiving that check, you've suddenly earned the fee. The truth is that until some work is done, that fee is not earned. But you can agree with the client as to when it is earned. That's in the comments to the new rules. So you can explain that maybe the first court appearance you make on behalf of the client, the fee is earned and can be withdrawn from trust. You can make whatever agreement you and the client are comfortable with. Just make sure you put that in the agreement. Not every flat fee lawyer has really given that a lot of thought before because we haven't needed to. So now is a good time to be thinking about that and how you want to explain it in your fee agreement. Now the fact is, not every client is actually going to agree that you can put it in your operating account. We can ask for that. As a flat fee lawyer, you probably want to ask for that. It would be simpler on your accounting and simpler for your cash flow if you're able to keep having the flat fees go straight into operating. But a client does have a right to say, no, I don't want you to spend this money just yet. I want you to put it in trust. So be prepared for that to happen and go ahead now, go open an IOLTA. Have it ready, because you don't want to be in a situation where you receive a check from a client, maybe you're not certain that it's going to go through, and you can't deposit it yet because you don't have a trust account, and they're insisting that it go into trust. To open an IOLTA, it needs to be at a California bank. There are some exceptions to this, but it's primarily that if the client has business interests outside of the state, an account for that particular client can be opened outside of California. But for the general IOLTA account that multiple clients' money might be going into, just open it in California. Now, if you practice primarily out of state, my recommendation is to open the account when you are in California on a business trip, and open it at an institution that has a local branch wherever you live and work. That just makes it easier. Now let's talk about what banks are eligible for you to have your IOLTA. You can't just go to any bank. It has to be an approved institution. The State Bar website has a list. It's a pretty extensive list. So if you're looking at any of the big major national banks, you're probably going to find them on that list. And when you go into the branch to open the account, take with you this form from the State Bar website. What the form provides is the required disclosures to the bank, and the bank will utilize it to report to the State Bar that the account has been opened. Also, if you take credit cards, you want to have that set up in advance too, to have funds deposited into your trust account. And you might believe that you can't take credit cards into your trust account. That's actually not correct. It is okay to take credit cards into your trust account, but it needs to be done properly. So find a credit card processor that specializes in law firms and works with you with your trust account. The way it should work is that when you run a credit card for a fee that's going into trust, the entire fee is deposited in your trust account. There's no subtraction from that fee for credit card processing fees. The fees should be withdrawn from your operating account instead. Most credit card processors outside of the legal field do not understand this and are not set up to work that way. Credit card processors who are approved by the ABA and other bar associations do know how this works, and they will set you up with funds coming into one account and fees going out of the other. So make sure that you have that set up properly if you take credit cards. And finally, before the new rule goes into effect, or before you start implementing flat fees under the rules, make sure that anyone involved with billing and fee agreements in your office has read the new rules. It's really important that there not be mistakes in this area, because mistakes in trust accounting and mistakes with fees are huge areas for attorney discipline, and that's best being avoided.